Go ahead, Dharmender.
Okay, can you hear me?
Yes, yes.
Okay, great.
So you can put it on slideshow mode and get started. Perfect.
Okay. Well, to begin with, I want to thank Nari for setting these sessions up. They're not only informative for people, but it's also, nice to be sharing the knowledge among the people. The topic, especially that estate planning covers, is with all the money that we would make, whether it's in the investment or whether it's in active earning, passive earning, in any combination that we do, estate planning becomes equally critical in at least to understand how these things work to help us plan out what's in store for us. And more importantly, what I wanted to draw attention to for people, whether now or whether they watch this later, is what happens when you don't plan for it, which is very critical. Meaning, when you didn't speak for how you wanted your activities should have been carried forward, who speaks for you and whether that's what you want? Because actions will be done whether you're there or not. So that's the criticality, I would say, in understanding how these things work. So as much as we talk about the money part, which goes into planning while we are still able to speak for it, also what happens when we are not able to speak for it. And I'm sorry if I keep bringing these topics up, but estate planning also carries the activities when we are not around. So in other words, in our absence, now that absence can be because we physically are not able to be present when something is carried on, or we are incapable of carrying on and speaking for it, or law decides that we are incapable. More importantly, we are not here to speak for it in our absence, completely absence, as in we no longer are in this earth. So the estate planning is a very complicated, complex, and broad topic to cover. We'll just go through a few of the basics just to get people start to think of it. And as we keep going through, as the questions come along, if this session needs to be carried forward in the next couple of more sessions, or if this is too basic and maybe we need to cover some more complicated topics, we can take it up as it evolves. So the money part is more about saving the money on healthcare and court costs that one may incur. Okay, let me say that, if you don't plan it right. And transferring the money to other people that are of your choosing. Or if you don't plan for it, who does the money transfer to when you're not there to speak for it? More importantly, preserving the family wealth that you want to be in control of how to spread the money or how to plan for it going forward. There are lots of legal documents estate planning requires or covers. We'll go through basic stuff here. Kind of gives you a broad understanding of where things are, and every person's situation could be different. I would say probably 95% of them, they all fall into one category, broad category of stuff. But as your situation becomes a little bit more not mainstream, or you have some special cases, you may want to think about more complicated setup. Thereby, you may need a professional to craft all that. There is a lot of ambiguity, as you can project yourself. In legal documents, nothing is as clear as written. So you just want to have the document as tight as possible so somebody else in the future, or when you're not there, is not interpreting in a way that you didn't want them to interpret. So you lock it up as much as possible. And that's where it varies from, who drafts the document, how tight it is, whether it's withstood the challenges in the court. As you get more complicated scenarios of who in your life may challenge those documents when you're not around, or when you feel like you're setting this up and somebody else may say, you're incapable and you're incapacitated, thereby certain things trigger, right? So you need, as long as we understand the rules, it may at least, get us start to think of it, of how do we do it? What is the category that we all fall into? Okay, so power of attorney is one basic document, I would say, every one of us should have. Healthcare proxy is more important than power of attorney, I would say. Living will, same thing. Last will, testament, testament, and then the trust. These are more, you may lose money if you didn't plan right. But healthcare proxy and living will affects you. When, in other words, those are the documents that you are setting up how you want certain things to be done to you when you are not able to speak your decisions. Okay. Any questions till now?
It's going great. Keep going.
Okay, great. Again, as I do want to, I don't want to cause distress to people, but we will be talking about situations that are dreadful. In fact, it's probably going to cause a lot of anxiety if you're not ready for it. But it's better to think of those than leave it up to somebody, because we'll go through it. It's not pretty not planning for these kind of things. Okay. So what's the power of attorney? Power of attorney is a legal document, and it sets you up. You are designating one or more persons that are called attorney. In fact, our agent doesn't have to be a legal profession attorney. It can be anybody that you entrust to carry on your instructions without them adding masala on top. Okay. So because you're giving them the legal power to act on your behalf when you physically are unable to perform or become mentally incapacitated. Now, a simple example is you could give a power of attorney to, somebody else, like a real estate agent, to buy a house or close on a house when you're not there, you're traveling somewhere, and pretty much every one of them is figured out. You know the document, this is what it needs to be signed up. Physically, you cannot be there that day. So it's a rudimentary signature of the documents. So you're giving power of attorney to somebody just for that incident. And it's as easy as that. But now extrapolate that into all the other uncomfortable scenarios that you are not there, but an action has to be carried on your behalf. What type of instructions are you going to give? We all know when we give instructions to somebody, let's say to my kid, and say, well, I want you to go do this and come back. Well, those instructions tend to be misinterpreted. Right now, apply that to consequential things. It could be selling a house that you didn't authorize, you thought you didn't authorize, and the guy has a power of attorney. You didn't limit it by the time, and now the guy sells the house, you don't even know it. Now, legally, you cannot challenge those kind of things, right? It's a lot. Obviously, everything can be challenged. But in other words, you want to understand the legality of what it is that you're giving authority to somebody and what can they do to you or on your behalf, thereby they are speaking to you. So you're setting up terms for your agent to make the financial decisions or otherwise. It doesn't just have to be financial, but 99% of them are financial related decisions. By the way, there are types of power of attorneys that are limited in scope for what they are. So if it's a medical related power of attorney, that cannot just go and then become a financial power of attorney, even though the terms may be pretty open and broad, because the title itself is medical related. They cannot be applied for the financial. So the law provides for all these, for laymen to succeed, not just some complicated attorney have to be involved all the time. And Pennsylvania is pretty good. Even these documents, one can bring it down from the internet, but then there's a template that you have to put as the first page where it's almost like a checklist. You're doing this, yes, no, yes, no. So it's one more time, almost like a cheat sheet summary of what it is that you're signing. And if you don't have that, underlying document is null and void. Okay, so because they must have gone through, general people, regular Joe on the street is not able to understand complicated language. They don't, they just signed away something that a lawyer kind of slipped it in. But if that thing is not captured, Pennsylvania doesn't even honor that. So stuff like that. So law does set things up for the regular people to succeed, but we have to understand how these things operate so we can play the game right. So setting up the terms. I'm sorry, go ahead.
Hi, this is Madhu. I have a question. Now, if all these points are covered in the will, do you still need a power of attorney?
Oh, yeah. Right. The thing is, will comes when you're not there. Okay. Power of attorney is when you are still alive. I'm sorry to use those words, but okay.
Yeah.
When you're still present and on the earth. Power of attorney cancels automatically upon the death. So it's just, you can have all kinds of power of attorneys floating around, but the minute the death certificate is produced by your survivors, your real estate agent cannot sell the house anymore, because it's just, when they go to sign on behalf of somebody, they have to provide the lineage of what gave them their authority. And they would be showing this power of attorney gives me the right, thereby I'm signing, and they both become part of the document. But if that date was after the death certificate or whatever, now that's the whole transaction is null and void. So going back to, so the power of attorney is you can create, modify, cancel while you're alive. You can keep modifying it, any number of versions. As you can see, that creates a complication, meaning how does one know which one is latest? In India, this is one of the worst problems that India faces. People just will come up with 4 years ago document by just aging the document and come out and say, well, you signed it on that day and thereby I did it. Or they'll future date it, let's say this is 2021, they'll come up with a 2020 document and you didn't even know that such a thing. So to protect all that, I'll go through later on. There's a better way to do it through, if you register the document, that doesn't mean that the other people cannot challenge, but at least it makes it harder for the other people when you're not around. Of course, if you're around, you could basically saying, I never wrote it. So thereby it becomes a whole new thing of proving who is the fraudster here, but not complicating the topic right now. But you can modify as many number of times or cancel it out, okay? So it's better when you cancel, modify any of that, that you keep registering and updating the register with the county or legal authorities in your jurisdiction, just so that your cancel is now memorialized by an authority as opposed to you just coming up with today saying, well, yesterday's date, I canceled it. Well, now it becomes, but if you register it, that authority producing the document that it is canceled makes it much more easy and a winnable case when you get into dispute. But these are live wire documents. That's the problem with these. And that's kind of what makes people filled with anxiety because you're playing with a live wire. Why do I even want to do it? But the flexibility that they allow, I use that example because I buy and sell the house. I'm not even there. Most of the time, I don't even want to know the closing documents. I just give the thing out. As long as the money is there, that's all I want to know. Because who wants to waste 2 days going back and forth with these guys? But that brings up the problem, right? So anyway, you probably can project all the different things that can go on.
Dharmender,
Go ahead.
yeah, can you explain the registration thing? I'm not sure whether we really need to register because if it is fully signed, witnessed, and notarized,
Right.
what
Exactly.
is the need for registration?
The reason I do come up to the thing is, if it is notarized, it's the second best. Okay.
Okay.
If it's registered, that's the best that you could do. Now, you don't need to register, you don't need to notarize. You could just have it on a piece of paper, right? But as long as it's witnessed by 2 people. But as you can see, if this was challenged, now think about you're in a court and the guy on the other side is poking a hole. The reason why you say you need witness is to say that I didn't just cook up yesterday. Well, now what if those 2 are your close friends? The fact that you are notarizing, then that means the notary person is on the hook to say, yes, that day I was in their presence doing it. Now, as you know, you can get notarized anything you want, right? I mean, I don't even go if I need my documents notarized. I just send it and the person, anyway, bottom line is there are multiple ways to get things notarized and you don't need to be there. Although legally speaking, you need to be there. But if you register it, poking a hole becomes that much harder. Okay. So the one good thing about any of these power of attorneys is they cease to exist automatically upon death. So you don't need to cancel it, anything. None of their authorizations, authority given out or spreading around in the world that you lost track of it, all of that goes away. Now, there are multiple types of power of attorneys, multiple kinds. It can be temporary, it can be permanent, depends on how you set it up. It's general, very broad, limited to a specific event. It comes and goes. Like what I was saying, like, you could be giving a limited power of attorney to somebody to sign on your behalf during the closing, you're not there. And then it ceases to exist because that event is over. Whether you closed it or didn't close it, it happened already and you're done, right? So there's no specific need again to cancel that document. But it's always better to just to inform the person to say, now you the power of attorney that I gave you, it's done. It's better to get an acknowledgement back from him, that person, to say, yes, I acknowledge it receiving a cancellation of that power of attorney. So at least, I always like, yeah, we always say it's not them, but another person in their behalf when they have some bad horns in their head, thinking evil things, can do lots of evil things. So it's better to just cover yourself in these kind of things. So now the power of attorney can be immediately effective or dependent on a specific event. In other words, you could set it up. When that happens, it triggers and then it starts to be effective and then it goes away. Attorney in fact is just a human, another entity that can act on your behalf, who basically doesn't have to be a legal person, meaning it doesn't have to be a lawyer or something that is trained to be, working on these kind of things. It could be my brother, right? That's a bad example. My brother's lawyers. It could be my daughter. All right. So like that, as long as they're 18 and not incapacitated, that they legally, in the eyes of law, they
Dharmender,
are like they're legal. Go ahead.
why are you not saying spouse? You are saying brother, sister, son, daughter, but you're not saying spouse.
You could say that. You could say, generally, answer is it can be yes. Generally, husband and wife, there are things that I'm going to cover up. Like health related is when you may be giving that right out to the wife, to the spouse, right? Financial related, they both are generally together when they make whatever the decision. If they are anointing another person because, they are not able to go. But you're right, it can be either one of the, as I said, it can be any other human, another human.
So I think the downside of being spouse is, you guys are traveling together, anything can happen, right? So
That's why generally it's,
yeah, so that is why it is better that it is an unrelated person who is not traveling with you all the time.
right.
Mary, when both of them are gone, the power of attorney ceases to exist.
Yeah, right. Well, hold on. No. The power of attorney is given out by the individual. Okay, it doesn't survive. In other words, when one spouse is deceased, it doesn't survive and then carry forward to the next person. There is no joint like that, right? It's one power of attorney. You're giving it to another person. Could be your wife, could be another 18-year or older person. And it ceases to exist the minute that person is done. Now, it does get complicated. There is a joint way of doing it in case you have an action that's joint, meaning, let's say you co-own the property and you both cannot be there. Then you could together give it out to another gentleman. Generally, it's better just doing two separate documents. Same template, Word document, print it, change the name, and then say, me giving it out to, Mr. X, and then my spouse will print the same thing, change the name, and then give it out to. So when they sign, instead of showing one document that authorizes them to do both, there are two individual documents that give the same person, because it gets murky. What happens if one person deceases and then the other person is still there? Does that mean half the power of attorney is still active? You know what I mean? It doesn't take much to just have two separate documents if it's co-owned by two people. And then both can give it out to the same person, and who then will sign one place where on behalf of me, and then another place where it's my spouse needs to sign, and then the same person will sign again.
Dharmender Dinaka here.
Yeah.
So by law, is the signatory of a power or attorney just a single person?
Correct.
Okay, so if you have to include your spouse, there had to be two distinct power of attorneys, is what you're just saying. Is that correct?
Right. Now, that law doesn't critically require to do it, but it's just a best practice. I mean, if any half-decent lawyer tells you to just have both of them sign, they, it's just not a good practice to have two people create a power of attorney to give it out and then have one attorney, in fact, or an agent. So in short, I would say you probably don't never want to do it. Just have two separate documents. You're in the clear, simple, and thereby, especially what happens is, it gets complicated. I'm just going to be saying stuff that's going to create distress to people. But, things can happen. One person divorces, then what? You know what I mean? So things all get, that's why my thing would be, it's simple and easy, just do it in two separate documents. Okay, moving forward. Any questions or is there a specific reason that you're thinking both should be, you want to create a document with both in it?
Not me. I was just extending what Satya was asking about how many signatories can they actually be. So yeah, I was just curious. That's all. So,
Look, from a technical reason, I would say it's probably not a good idea to have.
Correct. So I think like Dharmender explained, right? See, power of attorney, as soon as somebody passes away, it is no longer effective, right? So when a person dies, power of attorney also dies. So that means we have a joint one, and if you have one person passes away, then it's complicated, right? So it's better to have separate.
I mean, you could do another substitute, which probably is in the will. I mean, now it becomes complicated. What could have been a simple, we could just go, as non-lawyers can execute the document. Now, a lawyer got to get involved because they may have to show in the will that they anointed the beneficiary. Now, that's what I mean. So it just gets, but you could do it. Okay, because if you think about what is a power of attorney, it's my intent for somebody to act on it. Now, if I own the property, I gave a specific one, that power of attorney ceases. Anyway, I think it's better to just say you probably don't want to do it. There is a technical way probably to get done, but why? All right. So going back to this. So yeah, that's saying your power of attorney under your POA does not need to be a lawyer. It can be any family member, any friend, usually because you're trusting them with prized possession. It could be money. More importantly, it could be, as I'll be showing me, is some medical decision on your behalf. So you really want to think about who is that trusted person that's going to act on your behalf. And believe me, there are some services, okay, that you can hire for that. And they will just go through to the T, whatever you describe, that's all they'll do. But generally it's a family member is who that is. So types of power of attorney is general power of attorney. It's called general POA, gives broad rights to the agent, including right to make necessary legal, financial, or real estate decisions. So they could be deciding to buy on your behalf and you didn't even know it or like it because you once gave them a general power of attorney. Durable power of attorney is effective immediately after signing the agreement. This is a little bit, you want to pay attention to this. It gives the agent the authority to act on your behalf if the principal gets mentally or physically incapacitated. Okay, so this is the kicker, meaning it's definitely a good idea to have this, every one of us, okay? And at every age, I would say, 18 and plus, boom, you should have it. Because God knows when you need it. If you don't have it, people who make the decision for you, you probably won't like it, okay?
Dharmender,
Go
just
ahead.
a quick question. You have even if, is it only if or if I'm reading that sentence, to act on the principal's behalf if the principal gets right, or is there even, is that a choice there, or?
Which one, the durable power of attorney?
Yeah,
Well, it only comes into effect when the principal
is incapacitated, right?
is incapacitated. They have to be declared. So you could even, in other words, a person who has that authority, I'm just going to use word, let's say my wife, cannot just go, well, I think he's mentally incapacitated, I want to pull a plug. Okay. The doctors have to get involved and they have to declare that the person is physically incapacitated. Now, you could go through, and this is where you'll see the power of having that, meaning, what's a good word? I mean, the necessity to having that is you could be saying how many doctors have to get involved. Okay. One, my wife's cousin is not good enough. You want to be able to say two, one from Bryn Mawr Hospital and the other from Jefferson. I mean, something like that. If you want to go through, I'm sorry?
Excuse me, if that's the case, the durable power of attorney, the statement should say it gives the agent the authority to act on the principal's behalf only if the principal gets mentally, not even if.
So I will.
No, it's not. It's not even.
Yeah, I will explain what my
I
understanding
think
is,
it's
right?
inclusive, correct? It's
So the general power of attorney, right? It can be either durable or non-durable, right?
correct.
So if it is durable, even if the principal gets mentally incapacitated, it is still valid. That's what it means. So it is valid before, and even if the principal gets incapacitated, it is still valid. But there is another type of power of attorney called non-durable power of attorney, and that ceases as soon as the person is incapacitated. So that is my understanding.
Right.
Dharmender,
Go ahead.
couple of things.
Go ahead.
I think you are hesitant to say a lot of things like death and all that. Please feel free to say it because this is a fact. If you don't say it and if something happens, we don't know what to imagine in terms of what is happening. If you say exactly death or paralyzed, stroke or something like that, then we know what scenario we are talking about. If you say, let's say something happens, I don't know what something is. So number two, if I have a general power of attorney given to my wife, right, under any
Yeah.
circumstances, so she can take over and do all the stuff. Whether I'm incapacitated or not capacitated, I'm fully fine. She can still handle it. What is wrong in that?
No, that's, and again, those things, general power of attorney is not effective for making medical decisions.
That's a separate thing that we can have, right?
What do you mean?
A living will or something like that that takes care of the medical decisions. To pull the plug, there is a separate document
Yeah.
that we sign.
Right. It is right. Those are specifically coming. Right. Thing is, even if you have durable power of attorney, there is a thing called living will that is needed to make even more serious decisions. Okay. So in other words, a better thing would be, as an exercise we can go through, okay, is call the hospital system that we are part of. I'm part of Bryn Mawr Hospital here. You probably are Powell, I mean, big hospitals. If you just call them and say, look, I just want to make sure that I understand the power of attorney that you would honor. Okay. What do you want? They are going to need two separate things. Living will is one for them to make a decision for doing these kind of things. And there's one more I forgot. Living will is for you. I'll come to it. There's two. In other words, just having one is not good enough for them because the grave decisions that are involved, they want to make sure that it's clearly annotated. So best thing to do is call the hospital system and say, let's say I'm going to be committed to the hospital. Then what? What do I need? If I want to deny it, if I want to say accept it, what kind of power of attorney should one have? If I need to, somebody needs to pull a plug on me, what do I need to have? Living will is one. Definitely, they need to have that, right? So,
Dharmender, are you looking for advanced directive or is that the document?
no, it's coming.
I think, Dharmender, I think what you mean is the trust.
No,
That
Let us
living
go.
will.
Let us go slowly. He's going to cover it anyway. So I think let's
yeah.
keep going.
Yeah, there is, I know living will, there's another word for another one for it, because I go
Medical
through this
directive.
exercise, just for shits and giggles, I'll pick up a phone and then say, hey, in this scenario, what do you want? Just so I'm plugged in and I know that
There is the living will as well as the last will and testament.
that is, last will is what you want it to be, that's your will, basically.
Yeah, at the
You're
end.
not, when you're
Yeah,
not.
the hospital is not going to ask for the last will, right? So they are
No,
going to ask for the medical directive or the
right. Let's go through it. And I
Yeah.
apologize for, I should have been more prepared going through this thing. This document we prepared almost like a month. So some of this memory is not fresh in my mind. Apologize, but it's going to come as we keep talking. So the other is limited power of attorney. Just by the name, it comes and goes. Limited power for the event, which probably is very useful to know what it does for us to exercise in case some things are happening, we need to be there and we can't be there and stuff like that. And in the limited power of attorney, it usually sets the term of when it expires so that it's already spoken for. In other words, you're not specifically serving a cancellation of a power of attorney notice anymore because it's already done, right? That's
I think it meant probably the healthcare proxy, is it?
That's the one.
Yeah.
Right, that's the one. Okay, so the springing power of attorney or conditional power of attorney is applicable if certain event or incident occurs such as specific medical issues. So you could be saying it's almost like it triggers for it to come into effect when that happens. Medical power of attorney, this is the one. Medical power of attorney, it allows the agent to make healthcare decisions on the principal's behalf when they are declared incapacitated, or can include decisions about surgery, treatment, organ donation, and choice of healthcare facilities. So, let's say you're going to take anesthesia for some sort, and it's going to, you're going to be out for X amount of hours or maybe days or whatever, in case, some people have allergic reaction to the anesthesia, and what do you do when something's happened? So you're already spelling all these things out, what kind of choices they can make, and would you like to be in the hospice or not, and all those you could be setting things up, and during the surgery, do you want anesthesia or not? Do you want it to be, what level? I mean, you can go very granular in those kind of things, but again, in the context of what we're talking tonight, just to know that such a thing exists will probably get you to think about if you do need it, when you need it. If you then need it, you can then dive deep into how else to do and go about getting things, setting things up. Financial power of attorney, these are regular stuff. Most of the power of attorneys would be that, and then the healthcare related. With the financial power of attorney, the agent has the power to make financial decisions for the principal, for example, regarding taxes or payments. Just on the side, if you have an advisor on your stock account, on your investments, they make you sign a power of attorney in the million documents that you're signing with them. One of them is that. In other words, they are making choices on your behalf, because what happens is, again, this is off topic, but I'm just going to draw the parallel so you can picturize how this thing comes into effect. The custodial account that you would have, let's say with TD or Schwartz or Fidelity, is your account. You should be the one making decisions of buying and selling and this and that. When you hire an agent, an advisor on the side, for whatever the commission they make, they are basically dipping into your account, acting on your behalf as if you made the decisions, right? You can see now, if you legally go and go, I never liked you selling that stock. Why did you sell it? It could have made $1 million difference between buying and selling. You could go sue them. But because they would have made you sign the power of attorney, which you gave out the financial decisions on your behalf, and they then, in turn, they'll be saying, well, we are fiduciary, we only make the best decision for you, all that. Regardless of that, when they sold, you gave them the authority to sell on your behalf, and you have no recourse to go back and sue him and say, why did you do it? Because you signed the power of attorney. Right? So, any questions till now? Okay, so healthcare proxy, this is as much as financial related power of attorneys are good to have, they may save time. Healthcare related is the kicker. And I would suggest all of us seriously to invest some time, understand what these are, and set things up. It's better to set things up sooner than later. Money can come and go, even if some beneficiary even like gets the money, that's all fine. But, you know, when these things happen, when you don't have these documents, who speaks for you may not be to your liking, okay? So anyway, going back to healthcare. Healthcare proxies are a legal document that names the agent, same thing, they'll be then called healthcare agent. They make healthcare decisions for you, gives them access to your HIPAA information, which is, you know, under Privacy Acts, they otherwise don't have that access to information. In other words, you and your spouse doesn't have the access to HIPAA information. Even doctors, unless you sign, they are not supposed to read into it and act on as if they knew it. So that's why if you see it, when you go to doctors' places or hospitals, first thing they're making you sign the waiver is on the HIPAA, first thing, because that's a very seriously privately protected information. So healthcare proxies, they include limitations on care. You're including limitations on organ donations, allows or disallows your agent to discontinue life support. Okay, I mean, some people may say, well, you know, when this happens, I don't want to be vegetable. I'm done, take it off. And not having it, I have seen in my life, was a very, very tough decision for the kids to go through to make that decision on behalf of the incapacitated person. Okay, nobody wants to act brave or stupid or whatever to say, take it off, and they'll string you along. And if that's not what we want, this is the time to speak. Because at that time, nobody wants to be brave enough, I shouldn't say brave. Nobody wants to commit that act because you don't know what the person would have wanted or doesn't want it, right? In the olden days, people spoke of it. So you worded your preferences to all your nearby people so they knew what does the person want. And so that when you're not speaking, at least 5 people knew. So if one person made the decision, you're like, ah, look, you know, all 5 of us heard that he didn't like it, so thereby I'm going to do it. But in today's age, speaking to 5 people or those kind of things is very rare situation, right? If you have a document, better, much better. Including sometimes doctors might not act on it. That's another thing. Okay, no doctor, I shouldn't say no doctor, but many doctors bring in their personal preferences, religious or political otherwise, of not acting on certain things, even though that's maybe what, as a caretaker, you're saying, I know the person told me when this happens, don't do it, take it off. And I guess the doctor's gonna, I'm not gonna believe you. I can't do it. And then you're struck along. So to me, healthcare related power of attorneys are the most powerful document that one can devise while they are active. Again, money comes and goes, especially when you're not there. If some wrong person gets the money, who cares? It's good that if the person who you wanted to gets the money, but if they don't, that it's not that big a problem versus these kind of things, at least in my mind. So,
Hey, Dharmender,
yeah,
question. How detailed do these get? For example, if the principal is actually in the medical field and they know quite a bit of what could potentially go wrong if you're,
yeah,
if you're afflicted with something, right?
yeah,
So can they say, hey, if the doctors reach a point where you had to give me like, 50 cc's of ABC medicine, don't go anything more than 50 cc's, that kind of stuff. I'm making it up, but you see what I mean? Like how detailed can it get? Yeah.
like that kind of general answer I'm going to give is applicable to all other kinds of power of attorneys also. Here's the thing. You could animate very detailed every scenario, and then under scenario, what do I want? And for which, a document can get very voluminous, right? Now, or give an overarching, very simple couple of page instructions to say, I don't want the pain to be any more than 5 out of 10. If my lungs are 40 or 50% off already, and then, doctors come up with prognosis that, it's another 5 days, but he's in super pain right now. Well, some measures like that, which didn't have to go down to the limit of, to the level of, do I need to get morphine or not morphine? Again, it gives you all of that flexibility to put that in there, or just leave it up to the person that you would be entrusting with. And, a lot of times people just go spend a couple of days with that person just talking about various scenarios to say, under that, what do you want? Under that, what do you want? Because as you can see, not every scenario that may occur in the future can you already project what to be done, right? So as long as you set it up to say, well, my pain, I don't want to be any more than that. If I'm on ventilator for more than this, it's already hurting in my neck, pull the plug. Stuff like that. Again, sorry if I'm going through this. I know my friend's father went through that. Okay,
Dharmender, as a
Dharmender,
physician, can I just chip in?
Sure, go ahead, please.
Yeah. So, my background is a critical care physician, and I, have dealt with this many a times. So,
All right, you can add more value to this than I
I'm
do.
going to make it very simple because, we have our own power of attorney and things like that. So, I
Yeah.
think what you should have is 2 documents. One should be a living will,
Yeah,
just a broad strokes about what you want to do.
yeah,
And the second thing is that you should designate a power of attorney who is going to make decisions on your behalf.
right,
If you don't designate a power of attorney, then by law, at least in Pennsylvania, your spouse is the main decision maker,
right,
and then your children. That's how it goes in that order.
right, lineage, right.
Yeah. So what I would suggest is that when you make your power of attorney, you can also indicate what you specifically want to indicate there. So as physicians, we don't really go about morphine, how much morphine you want to give or the thing. The broad strokes will be, for example, do you want to prolong life or not? So you can write
Right.
that, no ventilator. So
Right.
for example, in our power of attorney and subsequent document we have documented is that if there is no meaningful chance of recovery, and we let that decision up to the physicians to make.
Right.
Let's say that, we would not want to be on a ventilator. We would not want to be on a feeding tube. We would not want to have meaningful prolongation of life. We have also indicated that we would not want to be fed through a feeding tube. We won't want to be on a dialysis machine if there is no meaningful chance of recovery. And there are guidelines that physicians use about that. So
Right.
I would say that these are fairly standard and straightforward. What physicians are really looking for is, one is somebody is going to make decisions for you, and what that decision should really indicate what you really wanted to have, but you are not able to make that decision.
Right.
And you've already indicated. So that is a very, very simple document that we the same, because after all, these are very complicated issues. And you can't really, if somebody has a bad stroke, for example, or dementia, then you can define, for example, if there is no meaningful chance of prolongation of, if you're on life support. I mean, if you have a stroke and you're not on life support, then you
Right.
cannot terminate your life, because that will be euthanasia. So we're not talking about that. If somebody is on a ventilator and that's sustaining your life, do you want to withdraw the ventilator? So that is a call that, that you can
Right.
indicate.
And Dinakar, in my experience, what I found is once you either go through, a lawyer or online services is the best way to, as I said, many scenarios are already covered in these online services that come up with. So they go through that. If to nth degree, if you keep wanting to, contemplate every scenario, they will give you unlimited choices of coming up with. Or as Shiva was saying, some broad information and how to cover it also will be there. So it's the level of detail will be your choice, I would say, in drafting the document. But nonetheless, as you were saying, they would rather not be the one making decision. They would want some kind of a legal document that authorizes somebody to do certain action to do. If you don't have the document, as you were saying, law recognizes there's a whole order of who and how things are recognized, wife, kids, and all that. You know, it's one thing to say, if I don't have any document, now the choice is theirs to decide for us, right, of what to do, and the doctors would listen to them. If they say, "No, pull the plug," they'll pull the plug, right? So that's the breadth of that power of the document, or intensity of the document.
Dharmender, yeah, thanks for clarifying that. I mean, essentially, like I'm kind of going through, as you speak, my durable healthcare power of attorney, and it has listed everything that you and Shiva mentioned.
Perfect.
So that's no different than the healthcare proxy, right? Or is that
Right.
totally?
Actually, I have a different slide. Various names that same thing is known by.
Oh, okay.
Yeah.
Yeah, because like this healthcare power of attorney,
Yeah.
has all this listed in terms of, authorization for admission or discharge or, medical, social service,
Yeah.
legal.
Yeah. Like
It
that.
was the previous slide. Previous slide actually listed all the names.
Yeah. Even
Okay.
it includes things like DNR,
Yeah.
do not resuscitate.
Right.
I actually went through someplace, I forgot where. There's various
Shiva,
names.
could you
Yeah.
please repeat the set of words that you said? Like, if there's no meaningful chance of, would you? I like that. I think I guess the standard phrase, I guess, right, Shiva? You may be on mute.
I
So,
think Shiva said the meaningful chance of recovery or something.
oh, recovery. Okay, I see.
Yeah. So yeah,
But Dinakar, we all probably should meet somewhere and go through this. Here is why I said, okay? As much as Shiva said is right, but I can tell you Okay, physical example in my life. Somebody who was on ventilator for 30 days, recovered, and the person is really good, no problem. Okay,
Right.
just to add complications to your document writing.
Yeah. So
Yeah.
actually, one point Shiva said struck me, right? So he said that if you don't have this healthcare proxy or medical power of attorney, then your wife gets to decide, and in the absence of wife, your children get to decide. And
Correct.
if you are going to nominate them anyway for decision as decision makers in this document, do you really need one?
You do, because you are also enunciating exactly the scenarios and how much power.
Right, right. Okay. No, that makes sense. Yeah, thanks.
I think it helps the decision maker in some point anyway, kind of thing. So
Correct, correct. Even if it is your wife making the decision, if you
yeah,
have the document which spell out your wishes,
yeah,
that helps.
That, yeah, exactly. Then it's like this. If let's say today you're not incapacitated, you get to speak for yourself. What do you want to be done to you? Right? Your wife doesn't overpower that decision. Let's say we want to get amputated, and your wife, even if she says no, I don't want to get it amputated, your word goes. Same thing in the document. If you give more and more uh, scenarios, descriptive scenarios, and then what do you want that to be done, that document will speak for you when you're not able to speak.
So one thing I would say is that, Nari, when you had mentioned that, the spouse could make a decision, it's not very clear cut in medical decision making that really happens. So, if you look at studies on looking at living will, uh, most of the time they don't follow the living will unless it is powered by a power of attorney and a decision maker that is actually, indicated in that power of attorney, because that is a very important decision that we look for. So a living will is only because in Pennsylvania, a living will is only valid if your life expectancy is, if there is no chance of recovery. And that's a very hard call for physicians to make. That's
Right.
why only a designated person can make the right call.
No, but in that case, your spouse becomes, she's already authorized, because I've gone through that experience. Even if you don't have any document at all, then the spouse is authorized to make a decision. The
Correct.
only thing is, yes, you can say spouse may get confused there because whether what should be the decision. So that way, the will is there, and he or she will get some kind of indication. Yes, he wanted that way. But if there is no will, there is no legal requirement according to me, because I've gone through their experience. And the doctors will ask you to sign some document, and you sign it, and your spouse becomes totally authorized to take a decision.
But it's better now think of the flip side, right? If let's say we put in a couple of days of work and make these documents, then you're ahead of all those unknown problems that can come up. Now you're able to speak for it. Now it's written down. Now nobody can overwrite that, right? Now that's it. There is no misinterpretation of, I heard them, we all know in, court cases that went on for years and a person was dragged on to be a vegetable. Wasn't there a case like this is about 5-10 years ago? She was in coma for like so long.
yeah,
Husband says,
Florida.
I want to pull the plug, but the mother and father says, no, we have a document or some unenforceable document, but something of religious nature that she would have never said it. And what happens there is she never had a document, right? So legally speaking, husband could have had more right to pull the plug, which he wanted to do. So eventually when they went to court, and court eventually decided, no, in light of not having any document, it's the spouse that matters, not the mother and father. Spouse said, pull the plug. Do you remember that case? But this, I want to say 5, 8, 10 years ago, this happened.
Parents, if the spouse is alive, then the spouse gets the first right.
Right. But as a
parents cannot decide.
as much as it's a cut and dry in our mind, as you can see, in that case, went on for a long time before court said, reinforced again what we are talking here, that husband indeed has more right. Well, if doctors there would have honored that understanding, there was no need for the court case. You know what I mean? So it is ambiguous. It depends on what I mean, Shiva probably can tell us. The hospital system.
Yeah, no, I think we understand the procedure, but
Yeah.
I think let's not spend too much time only on this, because I thought you also wanted to cover the distribution side, and I don't want to miss that.
Right. So
Unless you are planning to have another session for that, because I think
let's
this
go
particular
through.
process we
So
discussed
yeah,
a
we
lot.
are going to have two sessions. We are going to have two sessions. Let us make sure that everybody understands everything.
Exactly. It's better to go through
No, Naresh,
questions
the
at the
question
pace
is,
that it happens
it
instead
was
of
very important.
jamming it through at our pace.
You know, what,
All right, so let's go through that.
something happened, huh?
Now, Vinod Bhai, let's go through that at the pace that I want to control. So let's
Yeah.
go through that.
Yeah.
Okay, so anybody else have any questions or?
I think you reiterated the fact that it is up to you. I think right at the very beginning of the presentation, you said, Dharmender, that this is all reflects your wishes, kind of thing, and
Correct.
that's important. And that one you can identify those when you're hale and healthy, as opposed to when you're not hale and healthy. As simple as that. So
Right, and then also, as you can see, right, the ambiguity of what could happen when other person acts in your behalf.
Yep.
Is, I'm not even sure I myself will act consistently, a year from now compared to what I'm thinking today, let alone another person who
Right.
then bring in another complication of whatever, thought process they may have at that time. So if we were to have spoken for it, and that is recognized by law, in a way, you're taking control of that scenario
Correct.
situation.
So if let us say that you have the both the living will and the medical power of attorney or the healthcare proxy.
Healthcare, those are the two that I meant to say.
Yeah. So I mean, it is a different name, right? So living will, you get to choose different scenarios, and you want what you want the doctor to do.
Right.
In different scenarios. Does that override the medical power of attorney?
They complement each other. This comes under grave scenarios.
So
No, never. So the power of attorney has absolute right. So because you have designated the power of attorney to make the decision on your behalf, you cannot make the decision because you're very sick now. So that person will make the decision. But the living will is a path that the power of attorney. So the power of attorney you have chosen. So this person is going to follow what he would think that you would have wanted. And that is reflected in the living will. But the living will is a very nebulous document. So it has to be powered by the power of attorney. So I would say that everybody should have a power of attorney so that they can, if you think that this is important for you.
Right. So what happens if you say that let us say I don't want blood transfusion because of my religious beliefs or something like that.
That is nothing to do with the living will. Basically, a living will is, you can, if you say you don't want that, that is your right, because when you get blood transfusion, you have to sign a document saying that you're agreeable to that. That is a different thing. That's your religious right. But if you are, let's say that you have some religious this thing and something happens and you're not able to make decision, then you can put it in your living will if it's very important for you.
Yeah.
But
I don't know about blood transfusion, but ventilator is very common. Many people say, I don't want to be on ventilator.
Feeding, dialysis, these are the things that,
So Shiva, I am talking about a scenario where there is conflicting thing, right? So let us say you have written something in the living will, and what you are saying is that whoever is deciding factor, whoever has the power of attorney, healthcare proxy, can override what is there in living will. Is that correct?
Very rarely that happens.
Nari, just let me add one clarity and then we can talk. As you can see here in the first one, healthcare proxy designates another person. Living will is not about handing a control. It's describing what you want things to be done onto you. In other words, you're expressing your choices.
Correct. No, I understand that. But what I'm asking is, if both are there, then the proxy, does it override the living will? That is what I understood.
I don't think so.
Tough times.
No,
Tough times. So, the person whom you're designated is somebody that you really trust. And that person generally works on what do you want. I've never seen that conflict in my 30 years of
Okay.
practice. Never seen it even once.
Okay.
Where a proxy decision maker has his own agenda here, and
Right.
exactly.
that very, very, very rarely happens.
Okay.
These are all like very sad times, and they're trying to, in some ways, be in your shoes. So
Right.
I
No,
don't
I
think
think usually the hospitals decide whether they allow it or not, because even hospitals have a policy. When they have a copy of the living will, and they go by that strictly. So
that
generally,
is also
that
incorrect.
becomes the rule.
That is very incorrect. So I will tell you that we don't go by living will as often as, there have been lots of studies looking at this. The living will is only, as Dharmender has very nicely mentioned it, it is just an intent. It is not. So most hospitals will ask for a living will, but if you have a power of attorney, that's a very important step. So in ICU meetings, we often involve big families when we don't have power of attorneys. And the living will is important. I'm not saying it's not important.
That means if you make power of attorney, then living will has no meaning at all.
No, the living will is.
They both complement each other.
They complement each other.
No, I'm just saying if you have power of attorney, then if you don't have any living will, it's okay, because they can decide everything.
You should always have a living will, because the living will is a short document that that tells what you want to do or what you don't want to do.
Exactly, but it can be overridden, you are saying.
No,
It
as
can
I
be
said,
overridden by power of attorney. Then if you are given power of attorney, that means you have delegated everything already to somebody. You don't need to decide anything.
No.
Again, Vinod Bhai, I'll tell you one thing is that
What's the purpose of having living will if you have the power of attorney?
yeah. So they both complement each other. A living will is basically just
Yeah, but one overrides. It's not complement, it's overriding that. That's what you're saying.
it never is overriding. It's complementing to each other.
No,
Really,
I don't think. I think the word I use.
Better example.
When power of attorney overrides it. That's what everybody was saying.
I thought they were exclusive, correct? Living will is just related to what I see on the screen, and healthcare, power of attorney, or
Let me say it in a pictorially. Let me draw this, and then you guys think.
Yeah.
Healthcare proxy is about giving, is about authorizing, is about recognizing another person. Let's say it's not wife, it's my friend, okay? To act on my behalf, and that person is going to do it. Now, if I don't say anything anymore, that person can decide when to pull the plug.
Right.
But as Shiva was saying, the hospitals would rather not just unilaterally let somebody decide to pull the plug.
That's what I was saying.
What happens is if you have a living will on top of it, where you clearly mention, I want to pull the plug. Now you are basically making the hospitals, you're tying their hand.
Dharmender, that's what I said, but somebody said, no, even if it is there, the power attorney will override it, and they will take care of it.
Let me say it this way.
They can absolutely.
No, let me say it this way. Let me say it this way.
Yeah.
The reason for these documents are needed is this, like any other legal document, whether we sign, any legal document is subject to interpretation, is subject to other person wanting to act because they are convinced that document clearly says what you want them to do. Okay?
Right.
So, as you can see, there are millions of lawyers. There is no such a document that clearly can be interpreted only one way. There is no such document. There is no word, there is no sentence that you can describe that the other person cannot slice and dice and come up with, and then, Johnny Cochran is going to be hired, and then that guy is going to come up with his.
Yeah.
So the thing that you're trying to do at best is minimize the misinterpretation as much as possible.
Yeah, I understand. I think it's very clear to
that the
everybody.
other person
I don't think we should spend more time on this, because we had overall, I think we all are clear on what it is.
Right. Okay. So Having said that, remember I was initially started up saying hospital systems want 2 documents I couldn't recollect.
Yeah,
Now, these are the 2 documents. Now, even after having these 2 documents, they may still not honor what you want, but that's the best you could have hoped for, okay? So thereby, as Shiva will say, it's better to have it, at least you covered 99% of the topic. 1% is still up to the person. You may be suffering through the pain and morphine, and the guy doesn't want to do it because he interpreted the language some other way. We never know, okay? And that's where a beneficiary or a attorney, the person who you are knowing may be going to court and say, I'm going to compel the hospital to act because now the judge is getting involved, and judge decrees and says, yes, you have to pull the plug. That's what, in other words, at best, these documents are how clearly you write so that that person can interpret and do it. That's what you're hoping for, that there's no confusion, right? So simpler it is, the better it is. More complicated you make, in other words, more voluminous document you make, somebody's going to poke a hole at it. Okay. All right. Going back to living will. Living will's general language, again, as you start writing it, there may be multiple things that will come up, but just to give you starting point to the thought process is it's going to say, I feel especially strong about the following forms of treatments. I do not want mechanical respiration. I do not want tube feeding. I do not want antibiotics. I mean, stuff like that. So you're just coming up with what are your wishes and what are they? So you're basically clarifying them. Okay. All right. So I direct that treatment be limited to the measure to keep me comfortable and to relieve pain, including any pain that might occur by withholding or withdrawing the treatment. I mean, it's your wishes. What do you want in there? Not every situation can you contemplate, but you're talking as much as possible. Okay, so why you need a power of attorney in healthcare proxy? Many people, unmarried, no children, disinterested, meaning people who just want to leave it up and then say, I don't want to do any of this. Could be because they cannot trust a person, that they feel like they can, let the other person be in charge of taking the decisions for you. There are multiple reasons why you're not going to do it. I just wanted to be funny about it. So I just threw that out. If you are incapacitated and have not named someone to make health or financial decisions for you, court will appoint one. This is the kicker. This is why we need to make our documents. In other words, when there is nothing, there is something called court. So a default is already figured out by the system. If we like the default, okay, then fine. But our scenarios could be that we probably don't like just the default of whatever it is, because default tomorrow can change, and today we didn't know what those are, right? Case in point, guardianship or conservatorship is one of the examples that I just mentioned. When there is nothing spoken for, famous case we probably would have heard lately about conservatorship of Britney Spears, all because she didn't have a document. When she was mentally incapacitated, who is going to make a financial decision? So the father went, pleaded the court to say, appoint me in charge of conservatorship. Thereby, every decision from that point on, including who she can date, when she can marry, was all decided by the conservator. Now, what he did, the father smartly, is he shared the conservatorship with him and a commercial entity, so that at some point, if somebody wanted to sue him, it's just not him. He was basically overseeing what was this other commercial entity that was doing. Anyway, bottom line is, if you want to avoid all of that, because none of them end the way you like it, all right? It's better to have all of that. So guardianship or conservatorship will be avoided with 2 days of work, all right? All right, so power of attorney can allow for attorney, in fact, to pay your bill write checks, change your investment, buy or sell your stuff, open or close bank accounts, file income taxes, bringing lawsuits on your behalf, can allow agent to gift your money away. That's the kicker. They can act nefariously, keep gifting it to whoever, including somebody they know, to benefit their own. It becomes a court case to, find out and let the court decide that he was nefariously acting not in your best interest. The chances of winning those kind of things are very less, because you would have given a very broad authority for the person to gift, not putting a restriction on who he can gift to. Although court does recognize that you cannot, just because it didn't say it doesn't mean you can just act illegally, not illegally, immorally or unethically. Each state and jurisdiction has their own POA and statutory funds. This is important for us to understand. Each state, and I put jurisdiction because I don't know if some of you here are in Canada or some other place, because they call them province or something. They have their own recognized format. There's a header that they want you to keep. There's a set things that have to be said in there. Set notice have to be given in there. And if you don't mention the notice period, whole thing is null and void. It's better to plug into those and understand what those forms are. All these are pretty laid out in nowadays on the web pages everywhere. Or if you hire the services that you would take their help in writing these documents. And if you say I'm in Pennsylvania, or if you say I'm in Montreal or something, they probably will tell you what are the basic things, necessary things that are needed to be done. But it's better to do that final step without missing, because every other work would have been null and void if you didn't follow the actual thing. One way to get ahead of these kind of problems is maybe take the template document, write as much as you want, and get some paralegal or a lawyer, to bless it. And advantage there is because they also will keep the document within their possession, and they are by law required to act judiciously. So later on, if somebody were to be questioning the validity of such a document, at least that law office would be there. That's another advantage of being there. Okay, so power of attorney for gifting. You may allow your agent to gift away your money while you're alive, but you don't have to. The positives is Medicaid planning, minimizing some taxes, because they may be, thinking about when they are filing the taxes, they may see, I don't have to explain this guy everything. I know if he gives away some of this money to Delaware Temple, maybe his taxes will be low, and they just do it. Everything is fine. But the negative is that agent may dispossess your money or most of it, and by the time you turn around and look at it, your money's gone already. That's another part of the problem, right? You just got, as I said, these documents are live documents, live wires, like touching a current wire, electricity wire that you can't expect to not get shocked. And you just got to know how to hold it with full insulation and still work with it, okay? When you die, POA is canceled. At that point, your will is the operative estate document. So now we transition all the different things. When we are active, regular power of attorneys, when we are incapacitated, certain power of attorneys, healthcare, proxy, and the living will. And now, if person were to be deceased, now you're in this different phase of the planning, also the different phase of this document too, of this presentation that I'm making. But think of it like now you transitioned over into a whole new era here. what guides, what happens there, how you think about it, how you plan for it is a topic unto itself. So anyway, so till here, any of you have any questions? Nari, how are we doing on time?
So are we done with POA? I mean, POA, what is the next section? Oh yeah, let us finish this power of attorney section and finish for today.
Okay, yeah, okay. So,
Nari, can we look at his slide number 1?
slide number 1.
Yes.
He wants to
The
see
first,
the overall.
I wanted to
agenda.
see what was the agenda for this, because I personally feel we didn't cover certain items, and
Yeah, we are going to have.
those were very important.
Probably, Vinod, you joined late. Dharmender said we are going to have multiple sessions on this.
No,
Yeah.
I'm not saying so. I'm only saying that we cover the items that he mentioned in the first slide.
No, go to the next slide, Dharmender. Yeah. Did we? There was a list of all the documents, no? Yeah, yeah, this is the one. So we covered POA, we covered HCP, we covered living will, and then next session we can cover last will and trust.
Right.
Okay, let us.
That's what I was saying. So that one might require a lot of time. There's only 5 minutes left.
That's why we are going. We already planned to split it into 2. So yeah,
Okay.
let us finish.
Okay.
We have another 5 minutes.
Then it's fine.
Okay, so now that hopefully, if not, we can have one more session just to talk about that. No, because creating power of attorney documents, forget the money part, the healthcare part is very essential. Shiva, probably will tell you from the doctor's point of view, but from a pure practical point of view, I can vouch for it. Having it, not having it makes a huge difference. And not to mention, it gives you comfort knowing that certain things will be honored and done the way you would like it to be. Okay. So hopefully we all are at a point having convinced that we do need to create those documents. Now the question is, how do we do it? Either you can compose it yourself, looking around, Googling it up, various template documents, which are million out there, and pick and choose certain documents here and there, certain words, certain sections, sentences, this and that. Or search for online templates, which are, again, dime a dozen out there, all free. Consult an attorney who could give you legit options, and hiring a lawyer could be heavy on the pocket, but it's done right.
Yeah, some companies also have legal services.
Right.
You can check it out whether it is covered or not. Actually, I got all my documents done through my company's legal service. I did not have to pay anything, but it varies from company to company.
Right. So, or there are online services like LegalZoom and stuff like that.
Right.
They generally provide
Many
enough generic.
companies have that legal services benefit, and that is one of the, like, pay $5 or something per pay period, and then you get benefit of them making all the documents.
Right. And also another thing, I'm impressed with the way all of us as a group are generally coming together. I mean, forget the politics part, it's all fun and games and just to banter going around, but on a stock and commercial side, it's interesting, all of us are freely sharing the knowledge. One of them could be these kind of things, okay, of coming up with stuff and generally floating things around, or even have a group kind of lawyer sessions, right?
Right.
And maybe, you know, make a deal with somebody, some set of people. I don't know if anyone of here are already lawyers or not, or know of lawyers, that if, let's say, 50 people are going to make such a document, now you're going to get a
Yeah.
deal. If not, these things can go, I mean, I remember 4,000 by the time the whole thing is done. I mean, it's not
Correct.
easy, you know. But nonetheless, it's like saying we cannot be cardiologists just because we have seen operations on YouTube, right?
Right.
These things are serious documents. So as much
Correct.
as we think we can compose and online and legal Zoom ourselves, at the end of the day, it's better to have another professional person at least do a cursory glance and make sure that it's an honorable document, that somebody can indeed honor it. Because you don't want on a technicality, some font size being one or
Right.
period not there, and because, and now the thing again is, if who will fight it to make it invalid is the question, right? If everybody is honorable and they just want to overlook certain things that are not done right, it's one thing. But the problem with legal documents is you have to write it with an eye on there is somebody who's going to obstruct it. How are we not going to empower them? How are we not going to feed into them and give them a sitting duck that they can just, you know, squash it up in 2 seconds? And answer is, it's probably better to get a attorney bless it at the end of the day. Now, start to finish, if you ask them to do it, maybe it's going to be, you know, much costlier. But even as I said, as a group, we can strike a deal or whatever, or flush it out so their time involvement is that much less. But then again, at the end of the day, having the documents is the best thing to do. After this is
Yeah.
the probates and estate, and in other
Yeah.
words,
Let us hold on for next session.
yeah.
So yeah, I think great job, Dharmender. And so, are there any last questions for Dharmender or anybody?